Hello and welcome to episode 22 of the Legal Scoop, our webinar series here at LOMAD, where we discuss recent wins by our attorneys or even our staff. I'm Brendan Shannon. I'm an associate attorney here at LOMAD, and today I'm joined by none other than me. I'm going to talk about a recent win I had involving schedule loss of use, and if you're following along at home, last month Brian Prince came out and discussed schedule loss of use as well. So there's sort of a theme to our summer video series as far as the legal scoop goes. But I think this is the time of year where you'll see a lot of schedule loss of use claims, and it's just sort of a hot button issue that I think anyone in workers' comp defense is interested in. Now, particularly, I want to talk about a recent sort of in between win that I had involving schedule loss of use, and basically the facts are a couple months ago, claimant produced schedule loss of use evidence. And ultimately, following a deposition of the doctor was discredited and the claimant was found to have insufficient evidence of schedule loss of use. So therefore, parties were redirected to produce new opinions on permanency. Once again, the claimant produced a schedule loss of use opinion from the same provider who provided the same opinion and then who similarly testified incredibly a second time. We went into the hearing and sort of took the position, which is something that can be done in comp, that, while the doctor's not credible, the doctor's exam findings can be used to calculate the claimant's schedule loss of use under the guidelines. Now, there is board panel case law to discuss this. And sort of the practice pointer here is that something that I've reiterated time and time again on this show is that you want to have your schedule loss of use opinions, whether it be by an IME or a treating doctor, looked at by an attorney who can apply the findings and any diagnostics in the file to the guidelines to determine whether the schedule loss of use opinion is accurate. Frequently, they're not. I mean, the guidelines are not the easiest thing to apply, but I would say that it's sometimes surprising how often the opinions are excessive when you apply the findings to the guidelines. So there's board panel case law that says that in a situation like that, the board can, and same with the judge, can apply the guidelines to calculate the claimant's schedule loss of use based on the findings and basically just ignore the doctor's opinion. Now, some judges and sometimes the board will do that, and then sometimes instead they'll just say there's no credible evidence, which is what happened here. Now, in a case where the claimant in this case is not receiving CCP, that's a pretty good finding because now the claimant just has to produce an additional opinion on schedule loss of use and we can start from square one again. In a case where the claimant is collecting CCP, while we'll obviously get credit for any benefits that are paid to the claimant against the eventual schedule loss of use award, in that case, it probably makes more sense to potentially file an appeal from an insufficient evidence of schedule loss of use finding, arguing that the board has the authority to properly calculate the schedule loss of use award based on the guidelines. So basically the lesson for today, which is something that I'll probably reiterate even more in the future, is always get your schedule loss of use opinions looked at. There's a lot of money that can be saved in just taking some time to look them over. So that wraps up today's episode of The Legal Scoop. We'll be back next month with some more sweet wins from LOMAD. If you like this video series or any of our other video series, please subscribe below on YouTube, and we'll see you next month.